Every revolution starts in the minds of the people. Arm yourself for the war of ideas. Take back your life. Take back your liberty. Tom Mullen Talks Freedom.
Hello, everyone, and welcome back to Tom Mullen Talks Freedom. Today is February 19th, Wednesday. And as you know, I have said a few times on this podcast that for the first time in my distinguished voting record, over 40 years of voting, I voted for a Republican or a Democrat for the first time this election year. I say that with a little regret, but on net, I don't have any. But had my guest today won the Libertarian Party nomination, my perfect record would likely still be intact. And I'm talking about Jacob Hornberger. He is the founder of the Future of Freedom Foundation. He's got a resume as long as my arm in terms of what he's done for the freedom movement way back in the 1980s. He spent a couple of years. Well, first he was a trial lawyer for 12 years and then spent a couple of years as the director of programs at the Foundation for Economic Education, where you can find his writing and the writing of yours truly. And then in 1989, founded the Future of Freedom Foundation. His writing's been featured just about everywhere that will allow the truth to be told about the free society. So happy to have him here. Jacob, welcome.
Thank you, Tom. Thanks for the nice words, and it's great to be here with you.
So there's a million questions that are begged by some of your recent writing, but we were all very happy to see President Trump pardon Ross Ulbright for the ridiculous, I don't know how many life sentences he had for basically starting a website that some people did some bad things on. But there's another man who's hopefully not forgotten, who has similarly been prosecuted by the federal government, not for exactly the same thing, but to me, with a lot of the same reasoning, and that is Ian Freeman, the former and hopefully future host of Free Talk Live. I met Ian back in 2009 at the New Hampshire Liberty Forum when I was a newbie to all this. And he was nice enough to have me on his very popular show, Free Talk Live, very popular all those years ago. And he, in 2018 or 19, caught the attention of the federal government because he was running a business that dealt in Bitcoin and was ultimately prosecuted for several crimes. Jacob, you've written quite a bit about this. He's been in prison now for 5 years. And I read the article you most recently wrote and then the three that it linked to. And maybe you could start with the in reverse order with the one that says how I got interested in this case. What caught your attention about Ian Freeman's case and made you so interested in it?
Okay, well, first of all, he hasn't been in prison for 5 years. He's been in prison for about a year now.
I'm sorry.
That's all right. His case is currently on appeal. And I recently attended, along with about 15 other people, as well as Ian's wife, attended the oral arguments in the case. So that's the latest development is that we're waiting for what the Court of Appeals rules with respect to the convictions and sentences that he got in the trial court, in the district court. This is a federal court case. So the reason I got into this is that I had heard about Freeman's conviction, and I initially took a look at it, and I read in the mainstream press there on the internet that he had been convicted of fraud. That was the implication, and that it was a jury trial. So at that point, I said, well, I'm not going to look into this any further. I was a trial attorney. I have a lot of faith in the jury system and had an attorney. And I thought, well, I don't need to look at this any further. As a libertarian, I oppose fraud and the initiation of force. And so I just dropped it. Well, then I went to Pork Fest last summer, and I was talking to a good friend of mine whose judgment I have total confidence in. And I said, I was standing next to him, and I said, what's the deal with Ian Freeman? I mean, he got convicted of fraud. So my friend says, oh, that's a bunch of bull, just a total bunch of bull. So I was intrigued. So I started doing more research. And as you Google Ian Freeman, you just see fraud, 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 until I finally got to an article by Brian Doherty at Reason Magazine. That was the first critical article I'd read of what happened. And that intrigued me because I've got a lot of confidence in Doherty's scholarship and integrity. So I asked my friend to get me a transcript of the trial. And keep in mind that I'd been a lawyer for 12 years, a litigator. I did a lot of criminal cases, both in state court and federal court. And so I got a transcript. He sent me the link to it, which is a written transcription of all of the trial proceedings, all the witnesses' testimony, the jury arguments, and the jury verdict. And I finished this trial, reading this thing, and I'm bowled over. For one thing, he was never convicted of fraud. It was all just misstatements in the press. And I finally traced them back to a press release that the U.S. Attorney's Office in New Hampshire, where he had been convicted and which prosecuted him, had put out a false and deceptive and deceitful press release. First of all, implying that he had been convicted of fraud, which was absolutely untrue. And then also saying that he had been sentenced for money laundering, which is absolutely a lie, because they knew that the judge had already thrown out the money laundering conviction. So as I'm reading this, I'm realizing, my gosh, they have railroaded this guy. That there was an entire section under the money laundering conviction that the judge ultimately threw out, where they were the ones committing fraud. They got an IRS agent undercover to lie about who he was, that he started befriending Freeman with the aim of trying to find something on him. Watched him for about a year, buying Bitcoins from him. Let me back up a minute here. The reason they were targeting Freeman, the reason they're still going after him, is that he was one of the original sellers of Bitcoin in the country, in the world, really. I mean, he was one of the pioneers there in his hometown of Keene, New Hampshire. And he realized why Bitcoin had been invented was to restore a sense of financial privacy to people, which has been destroyed because of the drug war, the war on terrorism, and all the banking regulations, know your customer, all this other nonsense from the war on drugs. So Freeman's there not only selling Bitcoin, he's explaining to people why Bitcoin is so important to maintain your financial privacy, and they hated him for it. And they still hate everybody who tries to sell Bitcoin as a way to get around government surveillance. So that's why they started watching him, and they couldn't find anything on him. And so they tried to entrap him into committing a crime. The guy mentioned that he was a drug dealer, which obviously was a lie, but he was hoping Freeman would then sell him Bitcoins, and Freeman didn't fall for it. He says, I'm not going to sell anything to you now that I know that you're a drug dealer. That's it. It's over. And so Freeman had kiosks set up in stores there in Keene, New Hampshire, that sold Bitcoins, like vending machines. And so the guy says, well, I can go buy Bitcoins out of your vending machine. And he goes, no, you don't have my authority to do that. These were unmanned kiosks. So the guy goes and spends $19,000 of U.S. taxpayer money, buys Bitcoin, takes it to the U.S. Attorney's Office. They indict Freeman for knowingly selling Bitcoins to a drug dealer after he had said no. And so they got him.
Does that, I'm sorry, Jacob, does that constitute money laundering or no?
No, of course not. I mean, technically, if he had sold money to a drug dealer with the idea of knowing that he was a drug dealer and he was going to take these Bitcoins and convert them into clean money, theoretically, I think they could have gotten him on it. The money laundering thing is so nebulous. But the fact is that Freeman, he smelled a rat, or he's just smart enough to know you don't cross this line. And he told the guy, I said, if I didn't know you were a drug dealer, I got no problem selling to you. And in an ideal world where there's no drug war, you can sell things to drug dealers or anything else you want. They've made it so that if you knowingly sell drugs, Bitcoins to a drug dealer, knowing that he's going to launder this dirty money and trying to make it clean money, you're going to be guilty of money laundering. But Freeman had said no. That was the critical part. I will not participate this with you. So they charge him with this. It's incredible, which I argue in my series of articles is proof that they didn't have anything on him, that they were desperate to get him. And because when you engage in this kind of entrapment conduct, you know they don't have anything. And so they charge him with money laundering. They charge him with failing to register with the federal government as a Bitcoin seller. They charge him with income tax evasion. And then the fourth charge was a conspiracy to launder money. So there's four classes of convictions there.
And let me break in there and just ask you, the first crime we talked about was fraud. Was he ever charged with fraud? And if so, what was the basis? Who was he supposed to have been defrauding?
Yeah, that's a fascinating question, because that's really, if you Google Ian Freeman, all you see is fraud and fraudster and all this stuff. They charged him initially with wire fraud with respect to banks, but they realized that they had no case there. They had not defrauded anybody. So they dismissed those charges. They did not go to trial on any charge relating to fraud whatsoever. And if you look at the jury verdict, this is why I was just so stunned, because I was convinced, as everyone probably in New Hampshire that's familiar with this case is convinced, that he'd been convicted of fraud. This is what was implied in the press release the U.S. Attorney's Office sent out. If you look at the jury verdict, there's nothing about fraud. Now, what they did was, they apparently, when they raided Ian's home as part of this entrapment nonsense, they got his computer. And my hunch is that they went into that computer and found people who had been scammed by online lovers, like little old ladies. I call them the Lonely Hearts Club, that they're in their 60s or 70s. They fall in love with a guy on the internet, and they of course, they never meet him, but they have found love in their later stages of life. And so the guy says, well, I need money. And so they say, oh, I'm willing to help you out. I'm in love with you. They've never met the guy. So he says, well, contact this guy to buy Bitcoins and put them in my wallet. So the little old lady contacts Freeman, and Freeman had his own way of trying to protect people, because his Bitcoin business depends on ratings. And he would try to ferret out if somebody was being defrauded, but these little old ladies would lie. They wouldn't even let their children know that they had these online lovers. Or the banks, they would wire money from the banks, and the banks are supposed to do all that know your customer nonsense. And so they would buy Bitcoins from Freeman, and then say, put the Bitcoin in the scammer's wallet. And so Freeman would follow those instructions. But they never charged him with defrauding these little old ladies or conspiring to defraud these little old ladies, because there's no evidence that he did that. In fact, the government admitted in a pretrial motion that they were never charging him with conspiring with the scammers to defraud these little old ladies. But they put the little old ladies in the trial to tell what had happened to them, making it look like Freeman was this horrible guy for selling them Bitcoins. And that clearly had an effect on the jury. I don't see how it could not have an effect on the jury. Totally irrelevant. In my opinion, the defense lawyer should have been objecting sky high when they introduced his testimony, because it was not relevant to the charges. He hadn't been charged with fraud, but highly prejudicial. So that's the whole thing about fraud. The jury never convicted him of fraud, as I thought they had when I first discovered the case.
And the first thing that pops into my head, this sounds like it's kind of a well-known con, the Lonely Hearts Club thing you say, to maybe call up a elderly woman and do this. Now, I have to think that for every one who was scammed with Bitcoin with this scam, there's got to be at least 10 that they sent the money Western Union, but they didn't prosecute Western Union for participating in that scam, being on an unknowing conduit, correct?
Exactly. Well, and an even better example is the bank, where they had their money. The bank had to wire those funds to Ian. And so they went through the same thing that Ian was doing, asking, well, what do you want the money for or whatever? You know, banks are supposed to be real careful, supposed to ask a lot of questions. I mean, if you go to a bank today and you want to wire funds to a regular company, let's say you're going to buy some gold coins, they will ask you all sorts of questions at the bank. So why didn't they charge the bank? If they're going to charge Ian, why not charge the bank? And of course, they didn't want to touch the bank. They were after Ian because of this Bitcoin prejudice. The entrapment, Tom, indicates that they were very desperate to get him on something. Now they go off on this technical regulatory crud of, oh, you didn't register your business. And then they go after him on income tax evasion and then a conspiracy to launder money. So the judge throws out the laundering money, but he should have thrown out the conspiracy to launder money too, because who was he conspiring with supposedly to launder money? So the judge has clearly said there's no evidence of laundering, but all of a sudden there's evidence that he conspired to launder. It's ridiculous
Well,
because
okay,
there is
so
no
let's
such evidence.
well, okay, so he wasn't even charged with fraud, which is what everyone reports. He wasn't convicted of money laundering, which is probably something that most people think is a big bad crime. So now we're down to conspiring. I want you to explain the specifics of the conspiracy charge against Ian, but maybe you could just say for a moment, why does the government always allege a conspiracy in just about every federal case that I know of? What comes along with alleging a conspiracy?
Okay, well, first of all, he was convicted of money laundering. The judge let the case go to the jury. And then afterward, the judge issues what's called a judgment notwithstanding the verdict. As we all know, a jury verdict's final. You know, a judge does not have the authority, or a court of appeals does not have the authority to tamper with a jury verdict. It is absolutely final. But there's one exception. If there's no evidence whatsoever to support the charge, it's the duty of the court or the judge to throw out the charge. It is called a judgment notwithstanding the verdict. So the judge essentially found, even though the jury convicted it of money laundering, throwing it out because there is no evidence whatsoever to support the charge. So
So today it says, as we stand here today, he's not convicted of money laundering.
exactly. He's
Okay.
absolutely innocent of money laundering. That's it. The government started to appeal and then dismissed their appeal. So he is absolutely innocent of money laundering. What he's convicted of is conspiring to launder money. And to answer your question is in fact, let me digress for a second just to say it is kind of ironic that whenever you bring up for example, the national security state's assassination of President Kennedy, what's the thing they always say? Oh, conspiracy theory, conspiracy theory. The Justice Department is actually the biggest conspiracy theorist in the world because in every single criminal case, or 99%, the first count is conspiracy. I mean, they see a conspiracy in everything. So it's just kind of like darkly ironic there. But a conspiracy is different from the substantive count of money laundering. Uh, in order to convict him on money laundering, they have to prove that he actually laundered money, that he took dirty money and converted it into clean money. In a conspiracy, it's totally different. What they have to prove in a conspiracy is an agreement that he agreed to launder money, which is different from laundering money. So you can have a person guilty of a conspiracy who has never laundered money, totally innocent of laundering money. All they have to prove is you agreed to do it, plus what the law calls an overt act, a small act that moves you toward implementing the conspiracy. So that's what they get him on. They get him on a conspiracy to launder money. Now, I argue in all my articles, and I've written a new article after the Court of Appeals oral arguments in the case saying there's no evidence to support the conspiracy charge either. Just like there's no evidence to support the laundering charge, there's no evidence to support the conspiracy charge because who would he have conspired to? Now, you know, the natural tendency in these conspiracy cases is to automatically assume that there's a conspiracy. You know, it's just even judges get, you know, jaded and they think, oh, yeah, if there's a substantive charge of money laundering, then clearly there was a conspiracy too. Well, when I looked at this, I analyze it from a legal perspective, and I'm saying, where is the evidence of the conspiracy? So it's not enough for them to prove that he laundered money. He has to enter an agreement with somebody to launder money. Okay, so the government admitted that he hadn't entered into a conspiracy with the scammers. Okay, so there's no conspiracy there to launder money with the scammers. He obviously couldn't enter in a conspiracy with the victim. That would be ridiculous. So the only possibility left is he conspired with his associates in his Bitcoin business who were also selling Bitcoins. So that's the only rational possibility here. The only problem is there's no evidence in the record that he ever agreed with any of his fellow Bitcoin sellers to launder money. They never talked about laundering money. They sell Bitcoins. They all sold Bitcoins. That was their line of work. That was their business. But selling Bitcoins and agreeing to sell Bitcoins to people does not equal an agreement to launder money. And that's why I argue that this whole conspiracy charge should have been thrown out too. Unfortunately, his lawyer, yeah, go ahead.
Excuse me, Jacob. Are there co-conspirators named in the indictment?
I I can't recall that, to be honest with you. I don't recall what the indictment said. It's very possible that that in fact, I think it's almost certain now that I think about it that they did allege a conspiracy with his fellow Bitcoin sellers because they ended up pleading out, accepting plea bargains for light sentences like 12 months or 18 months or so. So they must have been alleging, as I recall it now, the conspiracy with the fellow Bitcoin sellers. Yeah.
Okay, but not with this government agent that told him he was a drug dealer.
No, there's no alleged conspiracy with him at all.
Okay. All right. Yeah, I'm sorry to have interrupted you. Go ahead.
No. And this is, as I was studying the appellate briefs, I got really concerned because his defense lawyer did not challenge the conspiracy conviction in his brief. And the thing about appeals is that if you don't challenge a conviction, you've waived it. And so his lawyer challenged the counts relating to tax evasion, relating to registration, failing to register. And the third one had been knocked out by the judge. The fourth one is left intact. And that I find very, very disconcerting because even if Ian is successful in knocking out the registration conviction or the income tax conviction, the other one is still left standing with one exception. His lawyer is making an argument that I think is persuasive, but is difficult under the law to sustain, and that is a spillover argument, where he's saying that the evidence relating to the entrapment was so prejudicial that it spilled over and affected the jury on the conspiracy charge, and that it should be remanded for a new trial where the jury would not hear all that prejudicial evidence that was clearly invalid. And I find that to be a very persuasive argument, but I think that the argument needs to be made. And in fact, I argue in my latest article that it's the duty of the Court of Appeals to examine this conspiracy charge and see if there's any evidence there, even if his lawyer didn't raise it. And if they say there's no evidence, I argue it's the duty of a court to knock it out on their own accord. Because
why did he not challenge the conspiracy charge?
His explanation is that he was up against a word count limit on appellate briefs in the Court of Appeals. Well, my response to that is, then you edit down your other arguments to make room for challenging all three. I mean, everybody knows that you can shorten arguments, and therefore you're able to challenge all three within the word count limit. Or you can also, from what I understand, is file a motion with the Court of Appeals asking for more words, saying this is why I need more words because I've run out of room and this is a complicated case dealing with Bitcoin. He didn't ask for that motion. So that was his explanation, that he was against the word count limit. Now, keep in mind, you see, this is why I think this is so troubling. The conspiracy count, Ian got 8 years on. The other counts, he got 5 years on. Now, they all run concurrently. They run at the same time. But from my perspective, that if you're going to be up against a word count limit, target the one with the longest sentence first.
Yeah, I mean, this to a non-lawyer, this is just like complete. It's shocking that would be the reason I didn't appeal the worst charge. Have you? Is it as shocking to you as a lawyer, or does this kind of thing happen all the time?
It is tremendously shocking. I mean, I sit there and I said, "Oh my gosh, he didn't challenge it. He didn't challenge it," and I'm like stunned by it. I'm stunned because what concerns me is the court saying, "Okay, we accept the fact that he shouldn't have had to register," which he really didn't. I mean, uh, on the registration charge, they're saying that when Congress passed the money transmission law in, I think, 1970 or something, and defined funds, the transmission of funds, there was no Bitcoin in existence. And so the government's position is, well, they meant to include any money at all. Well, Bitcoin wasn't money for a long period of time. In fact, there's still people who say Bitcoin is not money. I quoted an article from Forbes magazine saying they don't meet the qualifications of money. But the government's position is, well, even though Bitcoin wasn't invented in 1970, Congress clearly intended to cover Bitcoin and even cite Webster's dictionary at some point, which is ridiculous. My argument is if there's any doubt at all, you don't put people in jail for 5 years on congressional intent on something that you're not positive of. And so, but if they get that knocked out, defense lawyer gets that knocked out, and then there's still the income tax charge. That's 5 years. But get this, the IRS agent that takes the stand in the trial estimates what Freeman made on commissions on his Bitcoin sales and says, well, okay, he didn't pay taxes on these estimated amounts. So on cross-examination, the defense lawyer gets her to admit that she's never considered any possible deductions that Freeman has because they didn't meet with Freeman in advance like they customarily do with everybody. They just indicted him. And so so he got her to admit, you don't really know whether he owes any taxes or not. And she admits that. She says, we don't really know whether he owes any taxes at all. How do you convict a guy? I mean, the judge should have just thrown it out right there. So, but let's assume they throw out those two charges. That leaves the conspiracy count if the judges don't buy the spillover argument. And so, yes, to answer your question, I find that shocking. It's a Pyrrhic victory. If you know.
And if he's acquitted of everything else and it's just the conspiracy, I think the average Joe would say, well, look, if he just conspired and he never actually did it, that seems like that should be the lightest sentence. But getting back to that other question, the government always alleges a conspiracy. And just in general, maybe you could talk a little bit about how that affects the rules of evidence when they allege a conspiracy and how it affects sentencing.
Well, let me give you an example, a real life example from my legal career. I was practicing law with my dad. We weren't partners. He was a lawyer. And we had a guy charged in a conspiracy. It was either a conspiracy to possess cocaine or heroin. I think it was heroin. And there was three of them. They were about 20 years old. And they had never possessed heroin. Okay. They had just conspired. They'd agreed, let's go get some heroin so we can sell it and make some money. And so they made a couple of telephone calls, but it never panned out. They never could get their hands on any heroin. But the government was wiretapping their lines or something and indicted them on a 1-count conspiracy. That was the only thing they were charged with, just talking. It just shows you how vicious this conspiracy statute is. All they had done was talk about getting heroin. And so they're convicted. And so it's sentencing. All three of them are lined up there. They all have their lawyers. We're there. My dad and I were there. And the judge asked for comments from the lawyers. And each lawyer gives them plenty of time to make a case for a low jail sentence. The maximum jail sentence was 15 years in the federal penitentiary. At the end of this thing, the federal judge, who was called Maximum John, because he was from San Antonio, John Wood was his name, and he believed that he was going to win the war on drugs, as most federal judges do and most federal prosecutors, despite, 50, 60, 70 years of failure. They're doing their part to win the war on drugs. So at the end of this thing, Tom, it goes 15 years, 15 years, 15 years. Gave these guys the maximum jail sentence on the conspiracy. So the conspiracy is alleged in all these cases that there's a statute that says if there is a conspiracy to commit a crime, that's going to be another crime. It's thrown in there sometimes to make plea bargains easier for the prosecution. They'll charge somebody with like 10 different offenses so that they'll say, okay, we'll knock out 9 and you plead guilty to 1. It makes it look like, oh man, you've achieved a lot for your client, when really you haven't achieved anything, because most judges are going to run them concurrently anyway, all at the same time. So you get the 15 years on one is the same thing as getting 15 years on 10. But it makes it easier to get convictions. It's easier to show that somebody agreed or talked about doing something as compared to actually doing it. So it gives the government an upper hand in terms of going after somebody they're going after.
Is it still true that if they allege a conspiracy, then hearsay evidence is no longer prohibited?
No, that is not true. Those are two separate concepts. And now there are exceptions to the hearsay rule, but it's been a long time since I practiced law, but they don't have anything to do with conspiracy. They have to prove a conspiracy existed with competent evidence. And hearsay, as a general rule, is not competent evidence.
Once they, okay, all right. So that's not the case. I think at one time I had read that it was, but this is many years ago, around the time I wrote my first book. And as far as sentencing, at that time, what I understood to be the case was that if you were convicted of a conspiracy, you could be sentenced for things that other people in the conspiracy did, whether you had anything to do with them or not. It was just, somebody else I'm thinking of drug cases where they catch you with X amount, but then your supposed co-conspirators sold this tremendous amount more and you get sentenced for all of that. Is any of that still part of the system?
Well, that's part of the system generally on sentencing. That after you're convicted, the judge orders the probation office to come up with a background report so that he can determine what the sentence should be. Because usually it's a range, like from 0 to 15 years, like on a drug charge. And so in that pre-sentence report, they throw in everything. I mean, they'll allege all kinds of stuff. There is no evidentiary rules there. Everything can be done on hearsay or rumors or whatever. They'll throw in that, oh, you were selling drugs over here and you were doing this over there, or you put together a website where people were committing murder or whatever. So there's no rules on that.
And things you may not have been convicted of.
Things that absolutely you were not convicted of. It's just all rumor and innuendo and things like that. And it's impossible to counteract that. For example, in the example I gave you, where our clients got 15 years from the judge even asked each lawyer, is there anything in the pre-sentence report that you object to? And each lawyer would say, yes, Your Honor, that's hearsay in there. And there's no evidence my client ever engaged in that drug deal. This has nothing to do with a conspiracy charge. And there's all this innuendo and stuff because the DEA was convinced that they were over there transacting the drugs. So the judge says, absolutely, counselor, strike it from the record. I want all those things stricken from the pre-sentence report. Anything else? No. 15 years, 15 years, 15 years. So he gives them the 15 years anyway, but strikes it all from the record on the pre-sentence report. It's a vicious game. It's a real vicious game.
So Ian Freeman is caught up in this, and as we sit here now, he's still got some of these other charges. What's next for him? And if you have any idea, what's the timeline for him to have this go down one way or the other?
Well, he's got two options right now for freedom. And this is a man, like I've said in my articles, this is an innocent man. I mean, I have no doubts about it. I've read the entire trial transcript. There's no way that somebody should be convicted on this regulatory violation of failing to register with the federal government on a Bitcoin business. I should also mention that Congress later on, after Freeman was indicted, enacted a new statute clarifying that they now wanted to cover Bitcoin. So if it was so clear that they intended to cover Bitcoin back in 1970, how come they need a new clarifying statute? There's no question in my mind that based on that IRS agent's testimony that they don't know if he owes any money, that he's innocent of that. The judge found him innocent of the money laundering, and as I've said, I don't think there is any evidence whatsoever on the conspiracy. So he doesn't belong in jail. Right now, his case is pending before the First Circuit Court of Appeals. It's a 3-judge panel. They will issue a ruling, I would estimate, there's no real time limit, but I would estimate within 2 months of the oral arguments. It's been 2 weeks since the oral arguments. I think in the next 6 weeks, we can expect a ruling. If he loses there, he has the right to request what's called an en banc hearing, which is before all the judges before the Court of Appeals. I think there's 10 or 11. And if they grant that, then there's a new oral arguments before all 10 or 11 judges, huge, great big panel. That's hard to get. And then his other option, if he loses there, or even if he doesn't pursue that, is to seek a review by the Supreme Court, which is always possible, because I'm sure the Supreme Court might be looking for ways to weigh in on the whole Bitcoin controversy. And the registration charge clearly raises issues with respect to Bitcoin. The other option he has is a possibility of a pardon. Obviously very difficult, but President Trump has indicated a sympathy toward Bitcoin. As you mentioned at the start of the show, he pardoned Ross Ulbricht for the website there that he did, where they were transacting in Bitcoin. So there's always that possibility, but that sometimes takes influence. Do you know somebody close to Trump that is able to bring this case to his attention? I think if Trump were to see this case, I think it would stand an excellent chance of a pardon, because it's just so flagrant what they did here, trying to set him up and trap him. And that's the type of thing that I think Trump would say, oh crap, man, I'm throwing this stuff out. But
yeah, and he has declared, kind of support for Bitcoin, to be a pro Bitcoin presidency. Not that really that's not the issue here. The issue is that an innocent man was prosecuted for things he didn't do. And again, I just emphasize that the similarity to the Ross case, in that no one says that he did anything. It was that he allowed others somehow to commit crimes is mainly the reasoning here, that they don't apply to the bank, as you say, and they don't apply to Western Union or any of the so-called, conventional or establishment means that some people might use to commit these crimes, because you have to have intent to hurt somebody to be guilty of a crime. And there certainly wasn't here. I'll add too that this has nothing to do with the legal merits, but having known about Ian for all these years, back when I was on his show, it was the two hosts, Ian and Mark Edge. And Ian was the more, perceived as more liberal. If there was people that would criticize him, he was like the bleeding heart of the two, where Mark was more the hard edge conservative. This guy would never intentionally hurt anybody. It's just, that's my impression. Hey, I'm sure some ex-girlfriend could come out of the woodwork and say, "Oh, he's a terrible guy." But no, it's just nothing about this case smells right. Your articles just take them apart piece by piece. And yeah, this is a worthy cause for libertarians to take up and say, this guy is also being persecuted, not quite as hard as Ross Ulbricht, but very close. Any last thoughts on the case or its implications?
yeah, that I think it's also worth pointing out that, Trump was the victim of a lot of this malicious prosecution type thing, using the U.S. Attorney's Office to go after him on really, ridiculous charges, as well as the state prosecutions. And so it would seem to me that he could sympathize with what they did to this guy in terms of trying to railroad him with an entrapment and playing like he's a drug dealer, an IRS agent. I mean, imagine an IRS agent playing like he's a drug dealer. I mean, is that in itself is bizarre. What's the IRS have to do with that type of thing? So it really goes to show their desperation. And you're right, Ross got life without parole, which was a horrendously vicious sentence. And Ian got 8 years, but nonetheless, 8 years is a big chunk out of a guy's life who's about 42, 43. He's married to a woman, I think, who's about 29. They had just gotten married within a couple of years of his arrest. You know, there's a big difference between they don't have kids, starting a family when a woman's 29 versus 37, 38. I mean, this is the time where they probably want to start a family and all. And these feds have just removed an 8-year block of life from this man in his prime of his life. And it's just a horrible travesty of justice. And as a former lawyer, you know, it's just ingrained in you when you go through law school that there's few things worse in the legal profession than the thought that an innocent man has been convicted. And there's that old saying that from William Blackstone, famous legal scholar in British history, that said, better that you let 10 guilty people go free than an innocent man convicted. And so that's the thing. We need to lean over backwards to make sure that no innocent man is ever convicted, even if in the process you're letting 10 guilty go free, because it's so horrendous, the thought of that an innocent man spending 8 years in the federal penitentiary. And so, yes, you know, it took Lynn Ulbricht 11 years to secure the release of her son. Ian doesn't have 11 years. His sentence is 8 years. This is a cause that all libertarians should think about looking into and joining. There's an online site. I forget what it is, but I'm sure you can easily Google it. Sign a petition there. Several hundred people have already signed that petition. And the journey of 1,000 miles begins with one step, and every signature matters. This guy needs your help, and he's deserving of your help.
Yeah, well said. And thank you, Jacob, for the work you've done on this, just purely out of goodwill towards an innocent man. And hopefully you'll be able to come back, talk more about this case and many other things in the future. I appreciate your time.
Oh, thank you, Tom. It was a big honor, and I appreciate you having me on.
All right.
The war of ideas has only just begun. Arm yourself with the knowledge you need by heading to TomMullenTalksFreedom.com and subscribing to our email list. And remember, every revolution starts in the minds of the people.